May this matter be taken up on this coming Thursday with the consent of the other parties?
See, two matters have already been listed for Thursday. So why don't we make it on a Friday?
Okay, my lord,
Yes, Friday.
Mr. President.
May I seek a lordship indulgence regarding part 2, item number 5? I have taken the consent from the other side, my lord. If the matter may be taken up tomorrow,
Okay, tomorrow, noted.
highly obliged.
Motion item 1.
May it please your lordship. The petitioners were master role employees under the government of Mizoram in the PHC and PWD department. And their services were regularized on 22nd May 2008. In the year 2008. And thereafter, the respondent number 2 had issued an office memorandum dated 1/6/2020, whereby modified assured career progression scheme for the government of Mizoram employees 2020 was introduced, which shall be applicable to all regular employees under the government of Mizoram. And as per the scheme, there were to be 3 financial upgradations counted from the date of their joining the post. And the petitioners had enjoyed their first financial upgradation in the year 2018. Thereafter, the petitioner submitted a representation to the respondent number 2 for counting of their past services to enjoy the second financial upgradation. However, the said representation was rejected by the respondent number 2 by letter dated 7/10/2024. And the petitioners have come to learn that similarly situated persons were allowed to enjoy the second financial upgradation by counting their past services, ma'am, and being aggrieved there before this court.
Who are those persons?
My lord. Page 47, my lord.
Oh, they are not made a party in this
They are not made a
petition.
party. We were not aggrieved that they were allowed to enjoy the second financial upgradation, but we were aggrieved that though a similarly
Okay,
situated
so
persons,
where's the order showing that they have enjoyed?
my lord, page 47, my lord. Page 47 is their appointment order. And
Whose
page-
appointment?
those persons who were
Okay,
allowed.
okay, those, how many persons? 3, 4?
Yes, my lord. 3.
3, 1, 2, 3, huh?
And my lord, if I may take your lordship to page 49. This is where they were allowed to enjoy second financial accreditation. And closer to the annexure 11, page 47, goes to show that these persons, H.D. Vandal Lumuma, Ram Kuma, and K. Lalrinuma, had already enjoyed their second financial upgradation in the year 2018, 19, and 2020 respectively in column number 7.
But are they exactly in the same position as?
Yes, my lord.
You?
Yes, my lord.
There must be some ground. Past service count, 8
yes.
years, 9 years, 7 years, 10
Yes, my lord.
years.
Page 47 is their appointment order, my lord. 17 September.
Then we'll have to
2008.
see the rules, whether this is allowed.
Yes, my lord. At this stage, let notice be issued.
We'll issue notice, but supposing they had made a mistake for these 3 persons, which is not permissible,
Yes.
then, so I'm just thinking whether they should also be a party.
Yes, my lord. They have not made any clarification regarding that. That is one aspect, my lord.
So you're saying we should be as they are,
Yes,
isn't
my lord.
it?
Yes, my lord.
But if they have not been made a party, so
They-
how did they enjoy the 20 years? And is it there in their scheme? Because it appears that you have filed this only based on the fact that these three have been allowed the second upgradation. Nothing, you have not mentioned whether the scheme allows that or not.
My lord, at
Does it
page-
allow?
At page 51, my lord.
51.
This is the office memorandum dated 23/6/2020.
You see, you should base your this thing more on the memorandum or
Yes.
rules or whatever that you have a right.
Yes, I have based on those two grounds. One ground is that similarly situated persons were allowed to enjoy the,
But they have not
Past
been made a
services.
party anyways,
And
and you were not.
Yes.
Huh?
and based on this office memorandum, paragraph number 3, 1/3 of the service rendered on master roll provisional employee basis prior to regularization shall be taken into reckoning for the purpose of granting financial upgradation. However, though we were master rolls, and we have
Okay,
been
so
subject-
1/3 of this service rendered by you
Yes,
was not taken into
not taken into
consideration. huh?
consideration.
This should be a main point.
yes, that is my other ground. I have two grounds. my lord.
This should be a main point because they have been supposing they were mistakenly the
Yes,
thing,
yes.
then there have to be a party also that this is wrong. Okay, we'll issue notice anyways. Heard Mr. Zonam Chana, Learned Counsel for the petitioner, full stop, the new para. The instant writ petition filed under Article 226 of the Constitution of India is with regards to the rejection of the joint representation filed by the petitioners dated 7/10/2024, wherein the petitioners, where's the letter? 7? Where's the rejection letter?
The rejection letter is at page 46, my lord.
Wherein the representation filed by the petitioners were rejected on the grounds that the petitioners were not entitled to be regularized. No, that the petitioners
The nature of regularization of the petitioners does not satisfy the conditions prescribed by the MSC.
Wait. What you're submitting and the letter is slightly different, that's why.
Yes, my lord. The letter is very vague, my lord. That is why we are challenging.
This letter, I don't understand the meaning also. This is concerning their regularization, but you were already regularized, isn't it?
We are already regularized.
Huh.
They-
So
they-
why does it mention not according with the regularization scheme?
Yes.
But your case is not concerning regularization,
Not-
isn't it?
Not regarding regularization. It's only for the purpose of counting of past services.
Past service. So this letter does not address the issue at all?
Yes, my lord. That is why we are aggrieved, my lord. But still, it's a rejection letter. So that's
No,
the.
but what you're submitting and what this letter, what you are aggrieved with, is completely different. Anyways, we'll issue notice and see what's going on. Against the letter dated 7 October, okay, 2024. By stating that by this letter, they pray for upgradation under
MSCPS 2020.
the MACPS/20 20. Wait, let's make the full this thing, okay? It is modified, assured career progression scheme for the Mizoram government employees, comma, 2020. Within brackets, MACPS, comma, 2020, then close bracket. Was rejected. He further submitted that the petitioners were regularized on 2008 on their employment as master role under the government of Mizoram in PHE and PWD department. Thereafter, they had enjoyed their first financial upgradation by order dated 27/8/2021. Full stop. The petitioner had then submitted their representation for counting their past services for the purpose of enjoying the MACPS, 2020 scheme, which was rejected by the said letter dated 07/10/2024. Full stop. It is the submission of the learned counsel for the petitioner that other similarly placed persons were granted the upgradation by counting their past services as master role. Is it?
Yes, my lord.
And thus they should also be given the same right as those persons who are similarly situated. Full stop. Yes, issue notice to the respondents. Ms. Varne Isyami, learned government advocate, accepts notice on behalf of the state respondents. Anyone else?
No, my lord.
No need to issue formal notice. Requisite copies of the writ petition to be duly furnished to the learned counsel. List after 3 weeks.
Yes, my lord. Obliged, my lord.
Admission item 2 and 3.
Yes,
Your Lordship, my senior Miss Valentina is on lax in the other courtroom. If the matter may be passed over for the time being.
what is the stage? What
My
are
lord,
we
in this
waiting
case,
for?
my lord, in this case, we file additional affidavit, my lord, the contempt case, my lord.
You have filed or you're going to
Yes,
file?
yes. No, already filed, my lord. I will already
Already
file.
filed.
Reading is completed, my lord.
Okay, so then we'll make it a time being matter.
Time being, my lord.
Yes, time being.
Ali,
Item 4.
My lord, I am appearing in item 4, my lord, for the petitioner. My lord, I have instruction to appear in this case on behalf of the respondent number 2, 3, and 4, my lord. So, my lord, I am praying for 6 weeks' time to file our response.
Who is appearing for the petitioner?
My lord, I am appearing for the petitioner, my lord.
You are there for the petitioner. Okay.
My lord, kindly give any specific date on any Monday, my lord, after 6 weeks, because, my lord, I come from Calcutta. That is why, my lord, I am praying.
Okay, you're for the petitioner and you're for
On,
the...
on any Friday or
Okay, wait,
Monday, my lord.
you're for respondent number?
I am for 2, 3, and 4, my lord, income
2,
tax
3,
department.
and 4.
My lord, 2 to 5, my lord.
2 to 5. So notice is
2 to
complete.
5.
That means all the parties are duly represented. is it?
My lord, yes, lord. No, this has been-
One is represented also. Yes. Mr.
And Suman Chettiar.
VK Shrav, is it learned counsel for the
Yes.
petitioner appears through VC along with Mr. iPad, is it? Your good name, please?
My lord, I am Suman Chetia, advocate.
Okay, along with Mr. Suman Chetya.
For
Your this
respondent
thing
number
is there.
225.
Learned Counsel appearing on behalf of respondents number 2 to 5 and Miss Caroline K. Lalungoipui, Learned Government Counsel for respondent number 6 and Ms. Zarim Sangpui, Learned CDC for respondent number 1. It is seen that all the parties are duly represented. The Learned Counsel for the respondents to file their counter affidavit list after 6 weeks. Are you going to
Lordship.
appear in person sometime?
My lord, kindly extend the interim order, my lord.
Okay, so should we have a fixed date so that you can
Yes, ma'am.
appear in person? Okay,
Yes, ma'am, I
let's
would like to
after
appear in
6
person.
weeks on, give me a date after 6 weeks.
My lord, 28th
1,
of
2,
July
3, 4, 5, 6, yes. 20.
or my lord, 4th of August, my lord.
Okay, you're the petitioner. List
My
on
lord.
4th
Yes.
August 2024. Meanwhile, the learned counsels for the respondents are to file their counter affidavit by the next court date. Yes.
Lord, sir, kindly extend the interim order, my lord, by the
Is
next
there
day.
one? Meanwhile, interim order passed earlier shall continue till the next date of listing. Yes.
Grateful, my lord. Great. Obliged.
Item 5.
Yes, what is the stage? What's happening? Huh?
My lord, in the-
Custody. Oh.
Yes, regarding the custody,
Hmm.
temporary custody granted by the additional district.
You are the
session
father or
district.
mother? You are the
I'm the father.
father. The child is with whom? The mother?
As of now, it is with the mother.
Okay, with the mother.
Yes,
Fine.
before passing the impinge order dated 24/4/2025, the child was with me because the mother
Okay,
of
so
the
now the child is with the mother. And
Yes,
how old
because
is the
of the-
child? What is the age of the
he's
child?
only 9 months.
9 months.
Yes, when he was
Then
at
I
the age
think
of
with the
6
mother.
months.
Uh-huh.
Well, when he was at the age of 6 months, his mother, his biological mother, kept to me to look after the child, and she proceeded to go to Silchar just for her personal affairs.
But now she's taking of the child, care of the child, isn't it? Whatever her problem was then, but now she's fighting for the child, is it? So the child is just 9 months.
Child is only 9 months,
9 months.
but he's not a breastfeeding child.
Even then.
Then, in my lord, could you please take page 22 of my petition?
What is the father doing? Is he working?
As of now, he's not working.
Then how is he going to take care of the child?
He,
What is his income?
with the help of his parents, they all are getting together and take
Have
care
you
of the
tried to
child.
settle the matter in Lok Adalat?
No, not yet.
Make an attempt, because a child is not some commodity that you fight over the child. Okay,
Yes,
the child needs both the parents, mother and father.
That's right. He's not the material. No, he's not the material. Then
So
the mother.
therefore, why don't you make an attempt, sit together in the Lok Adalat? Okay. If
They-
it's necessary, you bring the child along also, but the child will not understand anything yet. Now it's 9 months the child is. So see what will be the best interest of the child, how to look after. Make at least one attempt
Yes, my lord.
to come to some settlement.
Yes, my lord.
Okay. But you have to keep in mind, the child needs both parents.
Yes,
Okay,
my
so
lord.
how are you going to adjust so that at least the child is not affected by the separation of the parents? Okay, you have to acknowledge that for the upbringing of the child, it's very important that the child should be secure and knows that both the parents are actually willing to take care of the child. So, yes, anything? Are you
Lordship,
willing to
yes.
try and come to some settlement at Lok Adalat?
If I may, Lordship, I would like to raise only one technical issues. This petition is coming under Article 226 of the Constitution of India.
Yes.
So,
Have you approached the lower court anyways? No.
Lordship, yes, it's now pending before the Additional District and Session Judge 1.
Oh, then?
It is now pending, Lordship. They are
It's still
also,
pending?
Yes, Lordship, exactly. So it's under trial. That's why, Lordship, referring Lok Adalat may not be arise as the case is now pending. And they have not yet filed a written objection also, Your Lordship.
No, Lok Adalat, if you settle it Lok Adalat, then you can tell the trial court, we have settled the matter, we want to withdraw. It's as simple as that. That shouldn't bar it from going to Lok Adalat. But only thing is, how come this matter when it's already pending?
My lord,
Yes,
because while passing the impingement order 24/4/2025, it is a violation of principle of natural justice. Because the land court did not give any opportunity of being heard, where the child is with our custody.
You try to
Then-
settle the matter, okay? And you talk to both, we'll fix it on Friday. You talk to both your clients, okay? Talk to both your clients, see if they're willing to come to some settlement. If they're willing to come to some settlement and the matter is settled in Lok Adalat, even if the matter is pending before the trial court, which we have to look into whether it's appropriate or not. Matter is still pending, and the court can take up the matter under 226 is also very questionable. But all those technical issues we'll not look into now. See if you can come to some settlement. If you can come to a settlement, this WPC and the trial court matter automatically becomes disposed of, isn't it? Then the simply way, it's a much shorter way and a more simple way to settle the matter if both of you are willing. Okay, and the child is just 9 months.
The child is-
Unless you show that the mother is very incompetent, I think when it's still an infant, it needs the mother. Okay, so let's see. I mean, that's just usual, but maybe she's very, very unfit. Something is there where you are aggrieved by the fact. You see, you're not going to lose your child. You're still going to be the father. Whatever happens, if you are the father, your being the father will never stop. Okay, that the court cannot take away. No one can take away you being the biological father. That you can rest assured. But for the best interest of the child as it is growing up, with whom should it be kept? That's what we have to look into. And whether it's appropriate under the 226 also, this we have to look into. Anyways, but in the meantime, you try to see whether you are willing to try and settle the matter. Once it's settled, all the other procedures that take a second place. Okay. Yes. So you talk to your clients first.
Lordship, yes. We report on Friday.
We list on Friday. In the meantime, you contact your clients and tell them that it is best if you can settle the matter, okay, and persuade them that it is better. But if you are not willing, you cannot force. Okay. Yes. Heard Ms. Jacinta so-and-so, learned counsel for the petitioner, along with Mr. So-and-so, learned Tila Lunciama, learned counsel for the respondent. On perusal of the matter, it is seen that the writ petition filed under 226 of the Constitution of India is with regards to the custody over a minor child who is aged only 9 months. Okay, and both the parties are the parents of the minor child. In view of the above, this court finds it appropriate if the parties should try and come to an amicable settlement. Accordingly, both the learned counsels are to inquire, instead of inquire, are to get instructions, okay, whether they are willing to have this matter referred to Lok Adalat. List on, what is Friday?
Friday is 23, Lordship.
List on 23rd of 5/2025, wherein both the parties are to come with the instructions from the clients. Yes.
Like your lordship.
Item 6.
Yes. Review. Yes, grounds for review. What happened? Are we prepared today?
We are prepared, but my understanding is that there's a change in the council of the
Yes, my lord. If
in
this
respect of the
matter can be
government.
fixed,
Mr.
somebody
Benjamin
can-
had handled the case earlier.
But does the government have anything to say in this matter?
Yes, they do, my lord, because
Okay.
they were the ones who submitted the clarification.
Oh, okay, okay. Anyway, heard Mr. Lal Fakoma, learned counsel for the petitioner. No, I think instead of you, it is Caroline who should make that prayer. Anyway, so cancel that. Mr. Lal Fakoma, learned counsel for the petitioner is present along with Mr. T. Lal Nunsiama, learned counsel for respondents number 1 to 4. Is it?
Lordship.
Well, full stop. Then Mrs.
Sorry, lordship.
One, sorry.
Only one.
Okay, learned counsel for respondent number 1. Then Mrs. Caroline K. Lungoipui, learned government advocate, has prayed for adjournment of the matter by submitting that the matter has been recently handed over to her since, from the previous government advocate. Or just make it recently handed over to her. What's happened to Mr. this thing? The learned government, Mr. Samuel, what's his name?
Mr. Benjamin.
Benjamin. What happened to him?
He resigned.
He resigned?
Yes, my lord.
Okay, by the previous government advocate. In view of the above submission, list the matter after. Let's make it in the next
Yes,
week.
my lord.
Okay, anytime in the next week.
Item 7.
Yes, what is the stage? Are the parties duly represented, both the parties?
Yes, madam.
Yes, my lord. Ms. Lal Lundu is appearing on behalf of respondent 1 to 3.
Government advocate, where is she?
She have already filed her affidavit in position, my lord. She is having personal difficulties today.
This is for what, admission hearing?
Admission hearing, yes, madam.
Pleadings complete.
Does it need extensive hearing or should we admit and then list it for hearing? At the admission stage, what is the matter about? At the,
This is challenge to the orders passed by the state government, order dated 6/9/2023 and order dated 29/2023, wherein the land of the petitioner was invalidated and a subsequent pass which was issued to the private respondents was validated.
so it needs some hearing?
Yes.
I don't think it can be disposed of in the admission stage itself. So we'll admit the hearing, we'll admit the this thing, writ petition and list it for hearing. Isn't it? What is the background? Just give me some idea. Where's the landed property?
The landed property is situated at Bongkot Brigade
Okay,
area.
when was it? So you have some documents?
Yes, we have valid documents. In fact, our land was issued prior to the issuance of the lands of the private respondents.
Okay, what sort of documents did you have?
House pass to LSS. We have all the required documents.
Okay. Then, when did you discover that your landed property was what, encroached or? So over the same land, another LSC was given to the respondents,
Yes,
is
my
it?
lord. Yes, my lord. And in fact, it was in the year 2016 that a civil suit was instituted before the senior civil judge. And in fact, 2 civil suits were instituted, and both were withdrawn by the private respondents.
So
And-
not settled, huh?
Yes, it's not settled. And in fact, there's an eviction suit pending, and that is kept in abeyance.
Eviction in your favor,
No, it's still pending, my lord.
but who is going to be evicted, you or the defendants?
Us, my lord.
We had filed against the
Okay.
petitioner.
Okay. So if it was withdrawn by the respondents, then how come there's a eviction, suit?
Exactly that they have filed, my lord.
Oh, so they had filed an eviction suit,
Yes, madam.
which is in their favor.
Yes,
The eviction
pending,
suit is
still
pending.
still pending.
So when the eviction suit is pending, why have you come in form of writ petition? Let that matter be settled first, disposed first.
Notes pertinently, my notes, this writ petition throws up disputes of factual issues in nature, my notes. To be decided in a writ petition, my notes, that would be our
No,
first.
and when there's a eviction suit still pending, let the eviction suit be disposed of first, isn't it? It's still pending.
It's still pending.
So they don't know whether you should be evicted or not. Then you come running to the court in form of a writ petition, is it?
Yes, my lord. But unless
Then-
there's a
then-
challenge to the orders that was passed, the orders
So,
issued by the
so
state.
can't you raise that issue before the learned trial court? By filing a counter WS. That can be done.
All the suits that have been filed, we had filed it, my lords.
Huh.
They have never filed a suit. If they had a claim of title,
So even if you file a suit,
yes.
but they can also still file their
Counter.
written this thing, and in your counter you can have a counter claim also, saying this is wrong, this is my stand, this. Because supposing we dispose of this writ petition, that means we are just cancelling the eviction suit which is still pending. That cannot be done. So in admission hearing itself, it cannot be admitted.
If that's the case, my lord, let my senior appear and let. the
Okay,
matter be
yes,
kept.
we'll have to see.
Yes, my lord.
So in the eviction suit, once the eviction suit is disposed of and there's an order for you to be evicted, then you file an appeal against that with whatever grounds you have, but you have to raise all those grounds in the eviction suit, which you have not. Have you filed written statement? Any counter claim, nothing?
Not at this stage, ma'am.
Then? Anyways, okay. Heard Mr. Roku Ngapautu, Learned Counsel for the petitioner, along with Mr. Jordan Rohintanga, Learned Counsel for respondents number
5 only.
5, and Miss Caroline K. Lalungoypui, Mrs. Lalungoypui, Learned Government Advocate for the state respondents, the Learned Counsel for the petitioner. We'll let Caroline, the proper this thing be represented also. See, it appears that there's an eviction suit pending
Yes, Lordship.
in the trial court. And in the meantime, you have come by way of a writ petition.
Yes.
So we'll have to look into the maintainability of the instant writ petition. But we will be fair, we will allow the concerned government advocate to be present.
Yes.
Then we'll fix it for admission hearing, whether this matter can be admitted in this form and style.
Yes,
So
Lordship.
my query is, when there's an eviction suit pending, then can you come before this court while the eviction suit is still pending? Because in the eviction suit, whatever ground you have in the writ petition, you can raise that by filing a counter affidavit, written statement, and make a counter claim saying that you have a right over the land. Then why have you come directly to the court in the form of a writ petition?
My lord, one thing is that we hear the main subject matters of the suit is that the order by revenue department. So we challenge that. So continuations after getting that order, they file eviction on the basis of that order, revenue order. So we challenge that order. So my lord, the thing is that before, on 2 occasions, they filed civil suit on 2015. First they filed.
That was, okay, that was withdrawn. That's a different thing.
And again they filed in 2016. Again withdrawn. Then they withdrawn. Actually, we object the withdrawal application also. We file review also. No,
They withdraw. You can go to the court also.
the story is that quite surprising. Then that the same party, they had directly gone to revenue, so they got the order directly cancelling my pass, because principle of natural justice is applicable in this case. And by that issue, by using that government order.
So do you have a eviction order from the court?
No, that first they filed it first order, then we file here and we got stay order by this honorable court.
Anyways, we will hear
Yes,
it in the
yes,
next
yes,
court
yes.
date. Let Lal Nunpui also be present.
Yes, need
Okay,
to be
because
present.
they're the ones who had issued the order, isn't it?
Yes.
Mr. JC, so and so. Okay, instead of this thing, Mr. JC is present. Learned counsel for the petitioner is present, along with Mr. John Rohing Thanga, learned counsel for respondent number 5. And Mrs. Caroline K. Lalnu Oipui, learned government advocate for the state respondents. The learned government advocate, okay, submits that this matter is handled by Miss Lal Nunpui, learned government advocate, who is not able to appear due to some personal difficulty. She has therefore prayed for adjournment. In view of the above, new para, in view of the above. List, when do you want it?
What about my lord, 12th June?
Why 12 June now? Okay, you are the petitioner. so
Yes,
it's
my
okay.
lordship.
In view of the above, as prayed for. List on 12/6/2025. Yes.
Yes, much obliged. Item 8.
My lord, I am for respondent number 1 to 3. I'm seeking another 3 weeks' time for filing my affidavit.
Yes, my lord, I'm representing the respondent number 4 and 5, and similar prayer, my lord. I'm seeking another 3 weeks' time.
I have received the copy of the affidavit from respondent number 1 to 3.
1 to 3 is whom? Ms. Zaram Sangpui. Mrs. Zaram Sangpui, automatically don't just pray for adjournment, see if you're filed also. Because when we see a face, it's always adjournments.
Yes, my lord. I have to check in, my lord. I'm sorry.
So have you filed? If the counsel for the petitioner has received your copy of your counter affidavit, then you must have
So
filed.
far as my knowledge, it's annexure is not eligible. That's why they have not filed. Even
Okay.
though before
Okay, so
filing
so you want a short date.
Yes, that's after 1 week.
But you're almost ready, that means. Okay, see here this thing.
Yes, my lord.
What about Vanessa?
Yes, my lord. Now the Parawais comment is pending with the law department for vetting.
Okay.
2 weeks.
Miss Dinari Tiazu, learned counsel for the petitioner is present, along with Mrs. Zaram Sangpui, learned CGC for the respondents number 1 to
1 to 3.
1 to 3. Along with Ms. Vane Isiame, learned government advocate for state respondents number
4 and 5.
4 and 5. What about 6 and 7 then?
Your lordship is.
Okay, none
See,
appeared for
yes.
respondents number 6
Even though
and
they have
7,
received,
though the postal consignment report shows that notice is duly served upon them. Full